All right, welcome back, everyone. It is our afternoon session on Thursday, January 30th. We are continuing the conversation around the Bennington 1 election. We are joined today by Paul Gillis, former Deputy Secretary of State, and he is joining us to offer perspective in a range of different buckets to the situation that we're trying to navigate right now in our decision-making process with the seat that is held by Representative Cooper. And we had met yesterday for quite a few hours with the petitioner, Bruce Busa. And Mr. Gillis, we did have we wanted to hear from you, your perspective on the decision and the process that we're engaging at from your lens as somebody who has, what I'm told, a vast amount of experience and knowledge in this subject matter.
Well, let me introduce myself. I was Deputy Secretary of State for 12 years when Jim Douglas was Secretary of State. And I practiced law for 30 years after that, and I'm now retired. And I've conducted 6 general elections and 6 primaries, and so I have some recollection of that. And in my day, the Attorney General's obligation to make the report always started at my office, and we did it together. So I've done some of those investigations. I read all the material, including the very good work that the clerk of the House has done, and I read the Attorney General's report, and Sarah Buxton has shared her materials with me as well. It's a conundrum. It's not a pleasant place to be. There are a lot easier election contests to decide than this one. I was interested in the conclusion that there had never been a precedent for this before, and sometimes that makes your decisions easier. I've also thought about how, if you were to go forward with calling a special election, how that would ever be. I have to say that idea disturbs me a little bit, and for several reasons. One of which is, who's going to be participating in this? Are all the voters of both districts, or somebody I think maybe suggested that just the 50 who were left into the wrong district should vote? I think it's important to keep in mind that Election Day is not just a date on the calendar, that it's the end of a process, and it's first of all, it's the best turnout we'll get. A special election wouldn't be the same, but in any way you move, you're going to end up sort of voiding the votes of those who had already participated. In several, or at least in one election case, I remember a challenge to a town clerk's office race in Windsor, I think, many years ago. It became clear to me from reading the literature that the overriding principle in elections is that election contests is that unless there is a firm conclusion that the outcome would have been different, that the default is to confirm the election of the person who was originally said to get the most votes. I don't know. I'm interested to know whether any of that leads to anything else at this point. How else can I help you?
Yeah, and so that's, I mean, your experience with this within elections is kind of what we wanted you to speak to. And so what the committee, I mean, the committee is wrestling with this decision right now where there is a sentiment to if we were to open it up to more voting, whether it be targeted or as a district-wide or town-wide special election. What would that look like? Which we recognize that is straying from the precedent of these scenarios that the legislature has had to contend with in the past. And then also just the swath of opinions about sticking with precedent where the results of the certified election are held in place, and we as the committee of jurisdiction then moves on with another piece of legislation when we work on our elections this year and trying to resolve the how did this happen and how do we prevent it from happening again. And it was really one of the things we wanted, and you have spoken to it briefly, that you shared sort of that sentiment of that elections, like recreating the moment is impossible. You can't go back in time. You can't recreate that snapshot in time. We had a very high turnout election. So, redoing the whole thing has got its own sort of conundrums to it. And that's really kind of some of the insight that we were hoping to just kind of glean from you, just given your experience. So the questions, is that anybody at the table have any questions? I know there's been some conversations around the committee leading up to this, because we're kind of at a point right now where we've taken a lot of testimony and now we're digesting a lot of information. And we just wanted to have you as a resource. So are there any questions immediately right now before we start? Representative Hooper Randolph.
I do beg your pardon if you mapped this out for us and I was not listening closely enough. But what would be your recommendation to the legislature if you were us?
Well, the decision I would reach would be to confirm the election as it happened on the day of election. But I would also expect that you would have to explain that. And that may be the more difficult part of it. Some people, some voters have felt that they were not respected. And it would be a shame to have them be discouraged, to think that their votes didn't matter. I think it would be, I think to go further, to hold a special election is a riskier decision. It's not, well, unprecedented shouldn't matter. It shouldn't be the deciding factor, but it just is so much more complicated to have to go forward and to start building a new checklist. What about the people that moved into town after the election? Do they get to vote? And is this a recreation of an election, or is this a kind of cleaning of the slate and starting over?
Right.
Representative Hango.
I just want to say that I want to thank you for appreciating the difficult circumstance that we're in. We're trying to get as many facts and opinions as possible so that we can weigh our options. And it is really difficult. So thank you for acknowledging that.
Now, was that your hand, Representative?
Maybe, depends on what you said.
Please go ahead, proceed.
Well, the thing that has bothered me is how much of this is actually our responsibility to cure. As opposed to, the many flaws that happened during the years and election cycles that this problem existed and wasn't addressed. I agree with you that running a special election is not very firm ground. But I'm sympathetic to the 40-some people that did not get to exercise their right to vote. How far do you think limiting the revote would be viewed as effective?
I imagine this compilation of votes, and I'm thinking we're going to add these new ones to the old one, and but there's something, the election law says that the day of election is the most critical thing, and it doesn't. What happens that day can't really easily be redone. Certainly not the same turnout. Certainly not the same political conclusions that people might have had on a particular day, at particularly consequential election day as we had in November. I don't think that you're going to have to address the question of whether you are disenfranchising people, or it's not. I mean, I'm sensitive to the idea it's not you that did it, but that these things happened and these things can be cured. I think part of your statement should be a sort of a commitment to make sure this kind of thing doesn't happen again. And clearly an expression of sympathy for those that got caught into this machine, but to cure it creates a bigger problem, I think.
Well, I'm sorry, what was that?
To attempt to cure it.
So I think the term cure is a little, in this situation, is a little ambiguous for me, because when I think about curing, it's going back and fixing something that we're allowed to fix, like a town clerk can cure a ballot, right? And I'm looking at one of our members as a town clerk, but I think what part of our mission was accurately stated, and that is going forward. There are a number of fixes that have been recommended to us for future elections. Our question here, in terms of the Bennington 1 contested election, is how do we make a determination of who should either remain in that seat or not? And I think that's what we really need to be focusing on, not so much as we know what went wrong. We know we'll have to fix that in the future, but for this particular election, we're looking at what do we do about the results of this election? We know that there were a certain number of ballots that were mailed to the wrong individuals. Representative Pincinel.
I'm going to put my town clerk hat on. If we were to make a decision today, or you asked me to make a decision today, it would either be, yes, there were lots of mistakes made by all kinds of different parties in this. So we let it go as it is, or everybody in the Bennington 1 district would revote. I don't think it's fair to ask just the 55. I think that's too small of numbers to know where the numbers might go. The checklist today is not going to be the same checklist that it was on November 5th for any, even on that street or those two roads, they could be different. It's the onus of the voter to make sure they're on the right voter checklist. And yes, during the redistricting, she put some on the wrong. The Secretary of State's verified that she did what she was supposed to do. It's not great, the results, and yeah, it stinks, but there's a lot of human error there. So either it's all of Bennington one revote in the Pownell only town, not all of the towns. Only the Pownell Ben one voters. Or no vote at all, and these are the results, and let's fix it going forward.
So I
Those, I
think,
think, are two options. I don't think we should consider the 55 as an option.
thank you for putting that out there, because that has been a concern that such a small number would either be personally identifiable, or for a number of reasons, we don't want that to be, we don't want people to be targeted
Right.
in any way, shape, or form,
Right.
because their vote becomes sort of known to the public through the small number of them. But I think you hit on something that the attorney has just told us, which is the checklist itself has already changed from November 5th. So we need to consider that. And I appreciate both of you bringing that up, because that to me is a big conundrum. And I'm not quite sure how to recreate the existing checklist that we had. I don't think you can do that. Representative Hooper.
Today has been a bellwether day with this discussion. I thank Mr. Gillies for coming forward and putting his experience on the table, and I thank you for that little, this is the list of problems speech, most of which I don't think are on our table to solve. And with the experience of our member from town clerk days, I think I've reached the point where I will be voting to seat the member that was certified and let the Secretary of State's office cure the problems and hope that it doesn't happen to come before us again.
I think by letting the Secretary of State's office, as you say, cure the problem, we would have to develop legislation in conjunction with the Elections Division to, going forward, have some tighter language in statute that would govern these types of election.
I think that if the language that's there was followed and all the tickers clicked the way they should have, it might not have been a problem to begin with. And the problem, I mean, started legitimately here with us drawing a line down the center of the street.
And that's definitely, I mean, those are the hearts of the steps to this.
But there were a lot of things that time moves forward, not backwards. There's a lot of things we can't go back and fix. So
You'd like to continue driving, Madam Vice Chair?
No, thank
go
you.
ahead.
Oh, but actually Rep. Pincinel, I think, might have something to say
Yeah,
about what I said about tightening up statutes.
Right. And one of the things that has been talked about in the town clerk world for many, many years is making mandatory training. And Mr. Busa did ask, like, who teaches the teachers, right?
Mhm.
So many times you'll say, God, I never see her at a town clerk's conference. Well, the select board won't let me take the day off. The select board won't let me close. I think it should be mandated. I would love to see a mandate that says the town clerk's offices will be closed on the second Tuesday of August or before any of the primaries or whatever for mandatory training. And you don't have to do it all in one day. You can do it in several parts of the state, but if you're in this corner, your day is that, and those clerks and title searchers could be warned ahead of time that those clerks are gonna be closed that day, because they're gonna go get proper training. Because when I look at the stuff that was shown yesterday, there's just red flags and nightmares on this whole process of how she kept track of her checklist and on the color coding and that shouldn't have happened in her on her official, voting, ORV, I can't get it's ORV, official record of voting. Those numbers didn't even line up into the right, like space that they're supposed to be, and it said no absentee ballots. Well, there weren't any absentee ballots because they didn't put them in the system as an absentee ballot received. They color coded them. That's, so I'm not faulting her because she may not have gotten the proper training. But there's just a lot of variables that are playing into this, that there are a lot of stuff that could have been done better, and at this point, I just think it's, and again, drawing a line in the center of a street, how many more of those have been done over the past 20, 40 years where we don't know if they're in the right district or not, others.
And those are the things we're really gonna mine into heavily once we
Yeah.
contend with this first step, right? And this has really opened up our eyes to some systematic procedures
Right.
that need to be more understood, and then more checks and balances.
And I think
put
you'd
into
get a
place.
huge support from the Town Clerks Association
Mhm.
to come in and testify on some of the things that they'd like to see cleaned up in the legislative bill as well.
Did I see your hand up, Representative? Yes, Representative Morgan.
So with what I'm just hearing, is our charge 2-seat or not 2-seat? Simply, is that what our charge is, or are we to put out potential courses of action other than that?
We have to make a defined decision. Whether
But
to
that could be
retain the
year to
member.
year.
No, well,
It's got a scope.
in this first step, Castle, please step in front speaking. We have to move forward with a formal position statement from the committee, voted out of here, as to whether to keep the election as is or go and open up some form of vote.
So those are,
That's
Course of
basically, and
action.
then there's like some other webs within that vote concept.
Right.
But
they're subsets.
yeah, and that's basically sort of the two situations.
So to seat or not to seat is one course of action. Another course of action,
Yes.
some level of.
Yeah. Yeah, Shakespearean.
The entire district, limited piece of the district. Because at one time I had it in my brain that, well, and I think Bob and I talked about it, was let the 44 that were of the 55, 6 that were identified, sent the wrong ballot, right? That did actually vote, let them re-vote. But I do, however, get the fact that now you're kind of pitting neighbor against neighbor because
It'd be unconstitutional too. So.
you could make it kind of squirmy for everybody, I guess is a good way to put it. But if you went to a larger set of it, you could do that as a course of action. Okay.
Okay, so if I could just pause right there with the committee discussion. Mr. Gillis, I think you brought a lot of valuable insight to us with your experience. Now I don't want to chew up your day watching us kind of have a committee discussion here. Now, if you do find it entertaining, please feel free to stick around. But I just wanted to check in with you and to see if you were still comfortable hanging out for a little bit in case we had any questions, or if you had anything to add at this moment.
Oh, this is fascinating. I don't mind sitting in your corner.
Then please, sir, be a fly on the wall. Yes.
And if you need to turn your video off for whatever reason, you can still just listen to us and you can come and go as you please. Thank you. We appreciate it.
And it kind of gets back to that like snapshot of time. The moment is the moment.
Yeah, I get that too. I'm just kind of up and down one day I'm one way, one day I'm the next.
It's a wrestle.
That's why we're taking this slowly, so we have the chance to do that. To really think about what all our options could be and what we've been tasked to do. And we're just all learning what exactly we're tasked to do. It's not what I thought it was when I first heard.
An old boss of mine once say it's a good day and we can break even, Michael. I think it's one of those.
Nice.
Representative Stone, did you have your hand up?
I did.
You do still, right?
I was just gonna clarify that we do have legislative counsel and the clerk of the house testifying, right?
Yes.
So a lot of these questions that people are asking and assumptions that maybe made could be clarified by a nonpartisan experts in the field. So I just wanted to,
Yep, we were gonna get there. I was just letting that happen organically for a moment so people could process thoughts as a group. No, I totally, I remember.
around a rabbit hole, I just wanted to.
Remember, I totally respect that, but I just saw it organically happening and I thought it was like a healthy moment to have that conversation as a group before we brought the,
A lot of questions.
Representative Hooper.
I, of course, am guided by our town clerk on this. Her reasoning, I think, is pretty strong. And I think there'll be a tremendous opportunity to create compromise, bipartisan policy as we fix this. And I think that we should maybe take Representative Hooper's suggestion to seat the member, move on, and get to work.
I appreciate that as a defined path. I really do. And with that, perhaps I will look over to our friends in the corner, council.
Would you like to join us?
For the record, Bethany Rask, clerk of the house, and I'll have a lot to add at this point. Just reiterate the point that I think I made in one of our previous conversations, which is that you all have the hard job because you have to make the policy recommendation to the full house. I'm here to support you along the way on any questions about the scope of your authority or the procedure you would recommend the house use. This is why you are the elected representatives and we are your nonpartisan staff. I just want to say thank you also to Paul Gillies, who is always wonderful to hear from. My work on government operations, always appreciate hearing from Paul. Thank you, Paul. But I'm here to answer any questions that your committee has, Mr. Chair.
So I don't think I have anything directly for you. I don't want to cart before horse. We're still having a couple of conversations here with the committee. I don't know if Tucker has any
Can I just
insight.
ask just for a reiteration, since Representative Hooper put a thought out on the table. We are tasked with deciding whether the current sitting representative retains his seat or not.
Making a recommendation to the full house for the house to decide.
That's right. And the House votes, and what comes out of here is either a resolution or what is the other document?
Sure. That's a great question, Madam Vice Chair. So you've been referred the petition and corresponding AG report. And so the standard practice is for the Committee of Jurisdiction to the standard practice, because our precedent has been in most cases or all cases certifying the seated member. It's in the form of a special report. So I can show you a couple of examples.
That would be
if that's
great.
helpful.
Thank you.
Because I don't, when was the last time? I don't think in the time I've been here, we've done a special report.
It's technically what it's called in the journal. So we have those two most recent examples from 2017 and 2011. So thank you again to Autumn for providing me with the ability to share screen. I'm going to share that now, if that's okay, Mr. Chair.
Please.
Oops. So I am taking us into the sampling of past contested legislative elections doc. And I am. Actually, do you mind if I back out? Technology, Mr. Chair, technology, do you mind if I back out? One moment. I'll take
That
it.
might help anybody watching learn where you're getting your documents from.
Okay. One moment.
Tracking our YouTube hits lately. How are we doing?
Are we content creators in that?
So,
You have a question?
I do. So while she's doing that, I guess I'm confused. So but I think what I'm hearing now is to seat or not to seat. But yes, exactly, Shakespeare. But do you 100% have the will of the voters of that district? And the answer to that is no. Because 55 or 6, whatever that number of people in that district were sent the wrong ballot. So I'll put that out there, but that's the thing that I'm on.
That's
Albeit not, and I know that's technically, but so. If the answer is, or I mean, the thing we're supposed to give a recommendation or whatever it is, I'm sorry, that's what you're saying it should be that we're putting out there is. Yeah, it's an awful conundrum to put us in because we don't truly know what that will of the people was because we had 55 or 6 people that weren't given the correct ballot. Am I wrong?
No, you're unpacking the conundrum correctly.
It's a problem.
Yes.
But the devil's advocate to that is not all 55. If all 55 of those people voted and voted on the wrong ballot, then I'd say, okay, that's their case. But several of them voted not to even vote.
Right, there were 44 that voted, I
Right.
think, yeah. That's why I had used that number
So-
before.
And for whatever reason, and.
So do you ask just those 44 to vote?
Right,
It's a constitution.
Representative Hooper Burlington.
And I'm sympathetic to all those points and have chewed them around a good bit. We've talked a lot about that from the day one where I said, we're a little yellow sticky, this is the solution. And that turned out to not be the solution. But it seems like every rock that we turn over, every question that we ask promotes 3 more. So I go back to that just principle of keeping it simple. And it seems like we have a certified election. It's flawed. We're not going to create a situation where the flaw will disappear. I think we can just make recommendations separate from this action that may prevent it from happening in the future.
So Representative Hango, then I'm going to go Representative Boyden, and then I will go Representative Shea Waters Evans.
So, Madam Clerk, my question for you is, the Constitution says that the legislature has the authority, only the legislature has the authority to judge the qualifications, elections and qualifications of the members, right? So elections. So all we're asked to do, from my point of view, is to judge the election of the member who is currently seated. Is that correct?
Within the scope of that term, judge the election, I think the menu is wide.
Okay,
Although I think the logistics are vary a lot, depending on what you recommend. We've taken a look at some of the most recent contested legislative elections. We've gone through that sampling doc. And in all the recent cases, the chamber, up to the chamber exclusively, has determined that the member with the results, the certified results, be it from the general election, a recount that was conducted pursuant by the county clerk or by the chamber's own recount, the member ultimately certified as the winner has been the member who has been able to be seated, either retain the seat Or in the case of a chamber's recount, it has in some cases flipped that winner. And so the chamber has seated instead the winner of the legislative recount. But otherwise, it had, so overall, it's been based on the winner of the existing election.
So I guess what my point was, thank you for that, is that we have a very specific task to judge the election. And how we go about doing that is a wide variety. And within that wide variety, what makes the most sense for us is what we need to determine. Okay, so does that totally clarify it for you?
No, it doesn't.
Representative Morgan? Okay,
I mean,
so
it doesn't. I mean,
we can recommend.
because if the answer is it's as simple as we have to just say seat or don't seat, then say it. Somebody say it. And if that's the case, then that becomes a very
Yeah, that's-
simple, either you can,
Yes, we have to answer that question.
That we do. That's what I'm trying to get at. We have to answer, should the currently seated representative remain seated?
but Betsy Ann just said, however, with the scope of everything available to you.
Yeah.
So we would decide how we just make that decision within the scope of this special report, which you were gonna show us, but we did have two questions for you. Next,
We are gonna go with
Boyden,
Representative
next.
Boyden first, please.
I have more of a statement that kind of loops back. I guess I'm just more so concerned about possibly opening up a new election of any sort, whether it be just the town of Pownell or the 45 or 55 people voting, and what sort of precedent or can of worms that may open up if it's discovered that this is also a problem in other districts as well that has not been recognized. Just more stuff to think about.
And that's a fair concern.
Yes.
I wrestled with that same thought, Representative. Representative Waters Evans, and then Representative Morgan, and then Representative Pisnall. In that order, please.
Oh, okay. I was gonna say, if he has a follow-up to what Lucy just said, because I have like a zillion questions and things to say.
Representative Morgan.
It's not false, it's just a simple statement on this. Yes, the gentleman lost is the same party of me, I will say that. However, all of us in this room know that whether the current person stays seated or for some reason there was another election held and the other guy won, balance of power doesn't change. So from that perspective, I have no dog in that fight. I really don't care. Well, you know what I mean. I think y'all know what I'm saying. I don't get best way to say it. I don't have a dog in that fight. It doesn't really, when the day is done, it isn't going to change anything in that regard. So it isn't like you're, with the US Senate when it was 50-50 and the vice president changes a vote or whatever. We're not there. So that said, however, I would place myself in the shoes of the guy that was not the victor and go, how would we all feel if we were him? And I'll just leave that. Like, I think that's where I bring in back the where he could question his questioning the will of the voters was not fully met. That's what I keep coming back to. But again, I realize either way, this election or what we decide to make of this election is not going to make any difference in the balance of power. So this means, am I making sense to people?
Yeah,
I understand.
absolutely.
And so I try to keep that as a nonpartisan thing in that regard.
Definitely.
Representative Waters Evans.
Thank you. That's an excellent point because it is political, but it's sort of not political. You know what I mean? Like it
Yeah.
could be perceived as such, but we're
Yeah.
really talking it as not being that. I appreciate you saying that.
Designation of the candidate is relevant to the conversation here. It is about figuring out how to execute this conundrum within an election.
Yes. So, so I have a bunch of questions and I don't know because what we're saying is, yes, so we have this question that we're trying to answer, right? To seat or not to seat. But within the larger question, it's, do we just make a decision without thinking of like the ripples in the pond or like thinking about the consequence, which would be if we said, we are not going to seat this person, So then we need to, what's the next step? And that's an election. I have a bunch of questions about. I don't know if Betsy Ann or Tucker, and maybe we don't know the answers to these. It is Tucker. Okay, should I wait?
Or, I mean, we're all here.
Okay.
Would you like to just hang in the corner sooner or come to the table? It's dealer's choice.
I do have one question though, getting back to what Betsy Ann was going to show us. Is that relevant to show us first and then have Tucker answer a number of questions?
Well, that's right. We're going to take a look at the
Yeah.
structure of the state. Yes, how this would proceed. Okay, so
Okay.
let's do that. You have your questions, which we have not
Thank
delved
you.
into, but they are well scripted and ready to go. So let's continue with Betsy Ann showing us some of the process.
Yeah. I think there's highlighted.
And you're at the sampling of past contested elections from Wednesday, January 22nd.
Yes, thank you. Madam
You're
Vice
welcome.
Chair. And yeah, as long as we were looking at the updated hyperlinks one, as the other version is not working. So I will show you, first, our most recent contested legislative election was in 2017. And so, what has been, the standard practice is, let's see, if I'll be able to open in a new link, new tab. Right. I'll show you this most recent example of a special report. Sorry, the link doesn't take you right to it. So going through this journal. Pardon the delay. So this was a different scenario because this involved the actual counting of ballots and the House was about to conduct its own recount, but it did not proceed to a recount that day. But I'll show you what the Committee on Government Operations reported out. It's like when you have a bill referred to your committee, you report out the bill. So this is just a special report. It's not connected to legislation, but it's related to your duties to make a recommendation to the House about how to judge this election. And so it starts out with language that's similar to your committee bill reports. So that it starts out by saying that the Committee on GovOps was referred the petition for the House to judge the election. And then the committee provides that it considered the same, and then you ultimately would state what your recommendation is. I'll note one thing also that has been so helpful from historical perspective is a motion to journalize the remarks made accompanying the report. It's been incredibly helpful to provide background on what the committee considered and what the issues were. Let's think about moving forward for the next committee in your situation, being able to have this information in the journal so you can look back at journalized remarks about what the committee considered and why it made its final recommendation. So that is our most recent example. I'm going to go back to the sampling doc and just show you similarly in the 2011 one, which is the other one I'm familiar with. It's again a special committee report. So just open that link. Page 132. Here we go. Similar thing. So here's a special report of the Committee on GovOps. Again, that the committee was referred to petition for the House to judge the election. And that, in that case, short and sweet, that the committee's recommendation was to find the seated member to be duly elected and qualified. And again, the journalizing of the remarks accompanies the report. So those are there. And I think it's very helpful for your future GovOps committee to be able to look back at these statements to help explain. I just wanted to note that your committee is really hitting on just how complex this is. And I've been looking back to try to find, I know you've been talking about potentially a revote and what would that look like. And when we discussed the other day, other examples and contexts, we talked about, for example, the two congressional examples from the 70s and 80s in the US House and the US Senate. So I'll just note here, this is going back, I just flipped over to this January 22nd memo that I submitted to the committee. I provided at the end references and other contexts. And I'll just note here, in Congress, which has the same, very similar authority throughout the nation of each chamber's authority to judge elections. The distinction here, for the US Senate in 1975, that was where they kept going back and forth. The winner, and ultimately the seat was declared vacant, but under law in regard to federal legislative elections, a special election is required to be held. So it's just by law that it's just a separate election.
Oh, that's the default, once it's vacated. Gotcha.
Set forth in our own statutes. That US House example, if you remember, we looked at that Congressional Research Service article and some of the remedies that were available, and they referred to a 1985 McCloskey v. McIntyre case. And in that case, if you look at that article, they refer that McCloskey case. So here, this is that CRS, Congressional Research Service research article about the House's authority to judge elections, and they provide on page 16 the potential remedies available to the House. Their last bullet point was that the committee recommends, a potential option is that the committee recommends the returns from the election be rejected and the seat be declared vacant and a new election be held. That was referenced on footnote. See this footnote here, 102, is in regard to the 1985 case of McCloskey and McIntyre. In that case, that was one of the only 2 times that the person who held the certification of election at the start of session was not seated. And so the House had just declared it vacant. They didn't have a member seated to begin with. So the House in that case did not conduct its own or order a new election. But going back to this sampling, Doc, the things that you have been discussing, the tension here about what is before you has been stated on multiple occasions, and it reminds me of the conversation in the 1973 Senate Chittenden District contest, Smith v. Fayette. Remember in that case, Fayette won the general election. Smith was the winner in the recount, and there was a special committee established to judge that election. And it was 2 members of the majority party and 2 members of the minority party. Member from Randolph, you had asked me about the data on the political makeup of the Senate at that time, and I was able to look back, and it was 23 members of the majority party and 7 members of the minority party at that time. But that special committee was 2 and 2. If you remember, they couldn't reach an agreement on issuing a report. So I found the
Or still that one.
yeah. But I found the journal entries really helpful and interesting. If you just want to take a look at these, we don't have to go through them in detail. This will just take a moment to load. But it goes through some of the things that the committee deliberated. And this was the case where they had considered holding that referendum in the town of Essex only for this whole Senate district. And this was not a majority report. They couldn't reach the majority, but it goes through what the recommendation potentially was. They said that, and this is a statement by the chair, who was joined by another member of the committee in making the recommendation to hold this referendum only in the town of Essex, and that those votes results be added to the totals of the other Senate districts. In this journalized remarks from the chair, it said that the AG considered the approach legally defensible, although it flagged that it could subject that voters could challenge that decision. And if you just read through some of the comments, it reflects the tension that you're feeling here about what the right option is, what your right recommendation is. And ultimately, they didn't move forward with it because, and so we don't know what that looks like. So I just wanted to reiterate that in all of our recent history, it has been certifying the winner of the votes that had been counted at the election, either at the court run recount or by the legislature or the chamber's own recount. Again, I think that it was helpful in that Senate case, if you want to take the time. I won't take up your time to do it now, Mr. Chair, but if members want to go through those journals here that I provided at the end of this Senate contested election, it will just reflect back to you some of the tension that you're feeling now.
And just for like a little digital housekeeping, we have two different versions of this. It's the updated one that has the live links. If you go to the first one posted, you will get the not live.
That was January 15th, the one without the live links.
The header just says updated. It's
We're broken.
Yeah.
Links were broken.
That's okay. Everybody bats 1,000.
We appreciate being given this level of detail. Representative Pincinel.
I wasn't sure if anybody wanted me to explain what it means to certify an election.
That might be a Tucker question when he comes up. Right?
But we still have Representative Waters that anticipating that.
So,
And now I'll get started, just kidding.
should we invite Tucker to come up?
Sure, Tucker may be able to help, but I don't want him to come up here before he's ready.
It's my turn to say.
I will frame the questions that I have for Tucker with this thing that I'm thinking about. Did you just say awesome?
That was just a general thing.
Oh, okay. I was like, all
That
right.
was not directed at.
Okay, so this is what I'm thinking about, like on a philosophical sense, about thinking about this issue before I ask all the questions that I have about like the technicalities of the revote and stuff, which is this, like, we keep saying, are we going to disenfranchise a voter? Are we going to take someone's vote away who already voted? Did these people, were they denied the right to vote for whom they wanted to vote, right? There are all these questions that we're asking. But then if you take it a step further and you look at, let's say we don't seat the representative and we say we need to vacate the seat and then come up with a way to have another one, then the questions that I keep asking myself are, okay, so then how deep are we going with then who else are we disenfranchising by having this be what our decision is? So we say, okay, let's start with the smallest population possible, the 45 people who voted. We know they voted before, let's let them vote again. But then are we saying, now these 45 people, there's a lead time up to that election where there could be campaigning, where there could be more money spent, where there's time to think, all of this stuff. Then do we say, these 45 people are essentially deciding who gets this seat, which means then are we disenfranchising all the rest of the voters and then what?
Yes.
So then you take it out one more level and you say, well, all these people are from Pownell. So let's let all the people in Pownell vote again. But then same question for the whole district, right? So then if we say we're gonna vote for, let the entire district vote again, then for me, that says there were people in Bennington 5 who voted on the wrong ballot. So we're reacting on who the winner is, which is why we're saying we should vote again in Bennington 1 and not Bennington 5, because the election was so close. But then we ask the question, if the principle of it is, are we giving people that, you know, a protected and important and sacred right to vote, is sacred the word I'm looking for, to vote, right? Which is their thing that they get, which is what we are all entitled to. Then you say, okay, so if that's the principle we're deciding upon, then wouldn't we have to also let Bennington 5 vote? Because there were voters who also didn't get their voices heard.
Yes.
Am I taking it too far for you? What I'm saying.
I understand the overlay member.
So if we are asking these questions, then all of a sudden it becomes this enormous thing where we say, are we deciding on the principle of what the vote means and what this vote means? Or are we saying we're going to decide on a really micro level who sits in the seat And then we take all of those other questions and work them into other things that we're going to do in the future to make sure this doesn't happen again, to prevent other legislature or other House of Representatives have to grapple with this decision, because we're going to make it really clear in statute moving forward, since we've already established we can't go back in time to November 5th, Tuesday of 2024. We can't even recreate the same political climate there was. You know what I mean? So I don't know. So in my mind, that is very long-winded and way of me saying, I don't think there's any other philosophical, principled way to resolve this issue other than to say, we seat this person and then let's figure it out and fix it for later. But I do still want to ask Tucker all my questions.
Okay, that was my
Right now,
next
I
question.
can be done.
Is that like just like, it's a wonderfully like put together oration.
Thank you.
To catch the questions within this.
Yeah.
So time for defined
I
questions.
told you I've been thinking about this a
Okay.
lot. Yes. It's our job.
Yes, Madam Clerk.
Thank you. I just want to make one more note on the for you before I before Tucker comes up, and I just want to go back to what you were saying about declaring the seat vacant. So I just want to note the distinction between declaring the seat vacant and what was suggested in 1973 in the Senate. We have statutory provision that unlike federal congressional offices that say when a seat is declared vacant, then there must be a special election to be held.
Mhm.
When we have a seat vacant in our legislative seats that the governor appoints
Oh,
a
right.
person to fill. And so I think that's just one thing to think about in regard to what they were considering in 1973 in the Senate, which is that if you look back at what the suggestion for the advisory referendum, it was SR 6 or SR 7 that was offered for that advisory referendum, that it specifically provided that the currently seated member was going to retain his seat pending the outcome of the advisory referendum. So I just wanted to note that distinction. Thank you.
Definitely
Thank you.
Station,
Just
conversation.
having a point another morning, right?
Thank you very much.
That's right. Or another hoop.
Another hooper.
It's time for more Nugents.
Yeah.
Okay, folks.
Good afternoon, Tucker Anderson, Legislative Counsel. I am prepared to attempt to answer any long lists of questions that have come up. I also sent to the committee a memo that is essentially just a guide to the statutes in Title 17 around, for example, the qualification of voters in elections, voter checklists, and procedures around things like challenges to the checklist. And I'll explain why I put that memo together for you in just a little bit. But I wanted to make sure that in the time that I have, answer your questions and give you the feedback you need. Sacred, maybe the appropriate word, sacred and blessing, both from, ancient language stems, meaning to shed blood in honor of something. So perhaps it is appropriate to say that voting is sacred.
Thank you. Metaphorically, yes, we're done. I have questions, but I have a suspicion that Tucker's memo and the things he's going to go over might answer some of those, so maybe we should.
Let's go over the document provided by council.
Excellent. So to give you some background, I was going to put a summary section here explaining why this memo was put together in the first place, but I'll just do it live for you. Both of the parties involved in this have given you either written material or exhibits that have pointed to the process around forming the checklist, reviewing the checklist, potentially challenging the checklist as part of the core issues that led you to where you are. In fact, some of the pleas that you have received from the parties are to address the voter checklist statutes at some point. So with that in mind, both for reviewing what has happened, but also considering your options moving forward, particularly if it is the committee's desire to recommend that a revote be conducted. I wanted to give you the statutory context for this process. So it's going to be disorienting, but you'll have a foot on the shore with what has happened and a foot in the deep waters, the unknown waters of what might happen if you structure a subsequent election. The memo starts with discussing voter qualifications for purposes of Vermont elections. And I brought my copy of the Vermont Constitution as my demonstrative, as Betsy has done for a long time in the General Assembly, to say we start at the top. And that is in Chapter 2, Section 42 of the Vermont Constitution, where the qualifications to vote for statewide offices are set out. States that every person who is 18 years old, a US citizen having resided in the state for the period established by the General Assembly, and who has taken the voter's oath shall have the privileges of a voter. The General Assembly codified this definition in Title 17, setting out in enumerated fashion, citizen of the US, resident of Vermont, taking the voter's oath, 18 years old. There are your voter qualifications. When we're talking about being qualified to vote in a municipality, a political subdivision, such as a district, residency is one of the key tests of your voter qualifications. The test for who is a resident is set out 17 VSA section 2122. By the way, I did take the time to give you hyperlinks to all of these statutes and get back to them later, which states that a resident is a person who is domiciled in the town as evidenced by an intent to maintain principal dwelling place in the town indefinitely and to return there if temporarily absent, coupled with an act or acts consistent with that intent. That is a long way of saying generally that a person demonstrates a combination of physical presence in the town and a demonstrated intent to maintain that presence indefinitely, as opposed to forever, just for a time after the present moment. No intent to move yet.
Thank you.
A person may be temporarily absent from the town and not lose their status. However, any person who removes to another town with the intention of remaining there indefinitely shall be considered to have lost residence in their original town. Further, 17 VSA 125 provides that any person who moves from Vermont and obtains residence outside the state shall not be required to vote in any Vermont until that person has again qualified to vote in the state. So if you leave the state under this statute, you are not permitted to vote in Vermont until you have re-established your qualification as a voter in Vermont.
Representative Hango.
And I just want to clarify that there are no time limits on either becoming a resident or not becoming a non-resident.
There are no required
Specific.
periods of residency, right? Durational residency is not built into this. So theoretically, you could arrive the day before the election, establish your domicile, which is, this is now my home. That's what that term means in this context. And you could have the intent to be here indefinitely. You have no plans to leave the state yet. And a day later, you can vote in an election.
And the day after that, you could leave if you so desired. Thank you.
If we feel comfortable with the qualifications of voters, something you discussed when you were working through some of the checklist material as a committee, we'll move on to the second big category of Vermont's election law that you have revisited a few times, which is the registration of voters, checklists, and related procedures around, for example, challenging the checklist. So some of the text that we've heard so far is about opportunities and, opportunities to challenge the checklist, to review the checklist, and to potentially correct or cure any errors prior to the election rather than after. Starting at the beginning, voter checklist is the official record of the persons registered to vote for a particular election. So under 17 VSA 2141, a minimum of 30 days before any primary or general election, the clerk must post the checklist in the clerk's office and in 2 other public locations. So you have physical posting of that checklist at least 30 days before the election is to be held. The checklist must contain voter's name, street address, or mailing address if that is applicable. The clerk is required to make a copy of that list that is posted 30 days before available to the chair of each political party in the municipality upon that party's request. Also must be made available to the officers with whom primary petitions are filed and to any other person upon request. And there are distinctions built into that statute that I didn't put here, but the reason any other person is separate from the chairs of political parties, representatives of the political parties, is that the political parties get access to copies of the checklist for free, and any other person who requests it has to pay.
And that's all by request, Tucker. None of it is a mandatory, you must.
Number 2 is.
Okay.
So number 2, which is the officers with whom the primary
I see
petitions
that.
are filed, that is not on request.
Thank you.
The town clerk has authority to call a meeting of the BCA to revise the posted checklist based on a particular challenge. The clerk posts a notice of the meeting and a list of the names that have been challenged and provides notice directly to the members of the board. So if there's a challenge at some point in that 30-day period, the clerk calls a meeting of the BCA, they review the challenge. The board determines whether the person subject to the challenge meets the voter qualification requirements that we just went over in 2121. And like I pointed out, residency is typically the big one, although I'll touch upon it later. Another big one is that the voter is now deceased. That is a fairly common one. But 90 days before the election, actually at any point up to 90 days before the election, the clerk and the BCA are permitted to do essentially systemic review of the voter checklist to purge names based on, for example, evidence that folks are deceased, no longer live in the state, things like that. If the board determines that a person does not qualify, the clerk is required to mail a notice to the person stating the cause for rejection and informing the person of the right to appear before the Board of Civil Authority. The board has discretionary authority to correct or transfer names on the voter checklist at any time until the closing of the polls on election day, provided that they follow the procedures that are required by Title 17. So there are some specific procedures that are required and some specific bases that are allowed to be used at periods of checklist review leading up to election day.
And therefore, again, no time set on notifying a person that they've been challenged and the board wants to remove them from the checklist. Correct.
Provided that notice is given to the individual. And we'll get to it a bit later, but there can even be an ad hoc challenge at the time that the voter appears to vote. So there's a lot of time here. And we'll touch upon some of the required issuance of notices as well. The board may alter the checklist upon the bases that are outlined in the statutes governing the alteration of checklists and removing names from the checklist. I didn't dig into either of those, but if at some point you want to talk about the particular bases that can be used under either of those statutes, it might be worth doing a deep dive on those two sections. A person whose application to vote has been rejected or has been removed from the checklist has the ability to appeal to the Superior Court for relief. So once you've received notice that arrives on a specific form that is set out by statute that you have been rejected in your application to be able to vote, or that you've been removed from the checklist by the board, that form tells you this is how you can immediately appeal to the Superior Court and potentially have your name added back to the checklist. We'll move on to page 3. The checklist at this point is now a inclusive record as to the eligibility of a person to vote in an election. By the time you get to the actual election day, this is prima facie evidence that this individual is eligible to vote in this election. The eligibility of a person on the checklist shall not be challenged on the day of the election, except by the special procedures that are established in section 2564, which we will get to. On election day, the voter checklist is furnished to the presiding officer of each polling location, and it is used to check voters upon entrance and this is only in some communities, at the exit point as they leave the polling place, unless the board or civil authority has voted not to use an exit checklist. So you have 2 certified copies of that presumptive checklist, right? This is now conclusive evidence of who's allowed to vote that is used to check people in at the guardrail. And then as they leave the voting location and pass back out of the guardrail, they state their name and they are checked off again. And this is important for a procedure that is used later. The parties, each candidate not represented by an organized party, and each committee supporting or opposing a public question, so you have 3 groups of people that qualify here, may be present at the polling place for purposes of observing the voting process and challenging the right of a person to vote. So they can be there at the polling place observing the voting procedures and potentially challenge the right of someone who's on the checklist. This challenge may be based on only one of 2 bases. First, that the person is not the person whose name appears on the checklist, or that the person has previously voted in the same election. The board is required to immediately convene at the time that the challenge is made to determine whether the challenge may be sustained. So I pointed to that kind of ad hoc challenge that can happen at the polling place. This is what I'm talking about. The parties can make one of those 2 challenges and the BCA has to immediately convene to either confirm the challenge or to say, no, this individual may vote. They take informal testimony and evidence at that time. And informal is stressed in the statute, indicating that it's likely that the voter will be allowed to vote because it can always be subject afterwards to challenge.
Representative Hango.
Thank you. So unlike on the floor, I'm going to ask a question that I think I know the answer to.
Different rules of engagement.
Right. So the only way a voter's eligibility can be challenged is 2 different ways: that they're not who they say they are, and that they are believed to have already voted in some other way, shape, or form. Not residency. Residency may not be challenged at the polls. Is that correct?
At the polls,
At the
all the
polls.
way up to the point of the polls. And remember, it's stressed and italicized that at any time up until the point that that voter arrives at the entrance, anytime up until then, that voter status can be challenged by someone in the BCA can also review. Residency, as we're talking about this, I don't want it to be confused with the instant facts that you're considering, right? Residency wasn't necessarily the issue. The issue was not even at the polls. It was the issuance of a ballot, incorrect ballot to voters.
So presumably if they showed up, they were gonna get the correct ballot for that district, if they showed up at that district in person to vote. So my stressing of this is kind of irrelevant, but I'm just trying to be really clear in my own head.
Noticing where the defect would have happened in the instant facts would have been if they checked the checklist and noticed they were on the checklist in the wrong district. Not that their residency was
So,
incorrect.
okay, thank you. That's kind of the road I was going down. So if someone showed up at the polls and they're on that checklist at that poll, but someone on the BCA or watching the proceedings realized that that person shouldn't be there voting in that district, could it then have been challenged?
I'm writing down a note so that I can get back to about
Thank
the
you.
authority of the board specifically to correct or alter a checklist based on a request of the voter who has noticed not that they are not eligible to vote, but that they have been put on the wrong checklist.
And before I call on Pistol, I just want people to be aware of time. We have a little bit more of this memo to go through. And I do want us to have 15 minutes to decompress before we go to the floor. So I would love to target a 10-minute arc to wrapping up this portion of the day. Representative Pistol.
Okay, so back to that question that he said he was gonna look up. I have had instances where somebody lives in the town of Mount Tabor, but has a mailing address of East Dorset. So they get put on my Dorset checklist because of motor voter. Right, that's how that happens all the time.
Gotcha.
So when they show up to vote, I know they shouldn't be on my checklist. So now that we have same day voting
Voter registration.
voter registration, I usually send them to say, look, you really shouldn't be on my checklist. You believe live in Mount Tabor, and they're like, yeah, I do. Like, okay, so go to Mount Tabor, you have plenty of time, you're up until 7 o'clock, go vote. If there are instances where I know they don't live in my town, but they're still on my voter checklist, and they want to kind of argue with me that, yeah, I do live here, but I really know that they don't, I never disenfranchise the voter and I allow them to vote because they're on my voter checklist. So I always let them vote because I don't want to disenfranchise any voter. And then I challenge them to going through the proper procedures because they weren't challenged when they showed up.
I
But now
understood
that-
what you're saying to the process.
So through the
like as
process.
It's laid out. Yep.
Yeah, so then I challenge him going forward. I mark it on my voter checklist that he needs to be challenged. I send out the letter. Hopefully he responds back with the postcard that I provided saying, yes, I do not live in the town, or I do not live in the town, but I still want to be a voter here. That can happen. Can keep you challenged.
I just have a quick follow-up to that. Would that person be voting in the same district, whether it was your town or Mount Tabor? Or the same candidates on the same ballot?
No.
Okay, good question.
So that's why I encourage them to go to their town because they're not, because they have their own. The state rep would be the same, presidential would be the same, but they're,
That was.
but
okay.
for a town vote or whatever, they
Okay,
would not.
so
have the
state
same-
rep would.
Yeah. Yeah, because we're in the same district.
Okay, that was my question. I wasn't getting down to the.
But you
town.
never, I was always trained
Yeah.
by Kathy DeWolf that you never want to disenfranchise the voter.
Thank you. All right, Tucker.
Representative Waters Evans.
I just have some questions about the revote process, and I think that's the next section of Tucker's thing, and I'm getting really nervous that we're running into.
Don't be nervous. Be aware.
Okay.
I will move on to that section now and also note that I am always at your disposal. So if you need to bring me back when you have more time to substantively discuss these things, You have me, that's all I'm saying. All right. You asked, previously some questions about the distinction between recounts and revotes. Both of the parties have talked about some of the distinctions between recounts and revotes, so I wanted to touch upon the statutory framework around both of these separate procedures for when you have an election contest. Under 17 VSA, section 2601, a losing candidate for state representative shall have the right to petition for a recount when the difference between the number of votes cast for a winning candidate and the number of votes cast for a losing candidate is 5% or less of the total votes cast for all candidates for an office divided by the number of persons to be elected. That's the situation you found yourselves in now, in your duty to judge this election. That happened in this case. I believe that the Attorney General's report said that the math mathed for that. The losing candidate has 7 calendar days to petition the Superior Court for a recount once that determination has been made. In the case of a petition for a recount in a general election, the Superior Court sets the date of the recount to be 10 business days after the receipt of the petition. So we are in the recount realm right now, just to be clear. Candidates nominate a minimum of 10 nominees for a recount committee. The Superior Court appoints a minimum of 12 members to the committee, and it can be more depending on the number of ballots that actually need to be counted. As a preliminary procedure, the county clerk, and I put this in here because of the checklist focus, is required to review the official return of votes for each town and record on the summary sheet for each town the number of ballots counted and the number of voters checked off the checklist on the town's return. When the numbers are the same, the checklist for that town shall not be examined for purpose of the recount. If the numbers are not the same, the procedures for examination of the checklist are initiated. Wanted to flag that there is a procedure in place that if there is no discrepancy between the summary sheets and the checklist count, once the county clerk reviews it, there is not an examination of the voter checklists. The recount is conducted under the procedures of 17 VSA sections 2602E and 2602F for the sorting, review, and recount of removed ballots by hand and by tabulator. Dove into those pretty substantially during the testimony this week, so I didn't want to drag you through those waters again, but we can always do a deep dive on those, just like the checklist challenge phases. If a recount results in a tie, the procedures of 17 VSA section 2602K apply, and a runoff election shall be held as a separate election. And the statute states that the runoff is held as a separate election. Only the candidates who appeared on the ballot are those who tied in the original election. The statutes governing the conduct of elections generally apply to the conduct of a special runoff election. So you have one instance where there is a runoff required, and in that runoff, it is a separate election, and it is held according to the statutes for the conduct of elections, which means it includes anyone who is qualified to vote at the time of the runoff election. It's not preserving the original election. With the exception of special elections held as a result of a tie, Title 17 does not contain automatic procedures for a revote following a contested election. So there's no automatic procedures for the revote after a contested election for officers. That qualification will become clear in a moment. Title 17 contains only one special procedure for a required revote, which governs instances where a municipal budget is rejected by the voters in a municipality that uses the Australian ballot system. And you just reviewed the statute in page 78. It is trusty old 17 VSA section 2680. And in that section, it requires, if you've adopted the Australian ballot system for budget votes and your budget fails, you must hold a revote. Title 17 additionally contains discretionary authority for the Superior Court to order a revote for purposes of resolving a contested election for offices other than the General Assembly, which Betsy has already covered with you all and flagged for you. So there is some parallel authority for contested elections that the courts can order remedies for them to order a revote as appropriate. This last paragraph trying to frame for you that what we have in statute for revotes and runoffs establishes that they are held as separate elections from the original election. Might limit candidates. In the case of the budget, it's just a vote on the budget. The entire annual meeting ballot isn't recycled and reconsidered. But all of the other provisions for the conduct of elections still apply. Which means that for purposes of those revotes, you are holding a new election. Those that have moved into the jurisdiction and have registered to vote are qualified to vote in those runoff elections and revotes. These are not binding on you. You could make alternative decisions if you were to structure a revote. But I wanted to highlight that under the current statutory structure in Vermont, that is how runoffs, the limited number of runoffs and revotes that we have in statute are structured.
Representative Waters Evans.
Thank you. So when you say we could make alternative restrictions if we wanted to do a revote, would this apply to this poor fellow who keeps coming up who moved to Alaska? Could we say we are going to allow this person who moved to Alaska to still vote in this revote if we were to say that needed to happen? And is that something that's allowed?
It is my understanding that particularly if you were to recommend a referendum rather than a revote, that you have many options. You are not constrained by anything but the Constitution.
Okay.
It's also worth noting that there are potential vehicles that could be used to garner the feedback of the voters. For example, the referendum that would not be the same as an election. And if you would like more analysis, I'm happy to come back and answer some of the specific questions about who may be qualified to vote in a revote, when, and how.
Yes.
Representative Nugent, and then it's a wrap.
All right. So when you're talking about the instance where the revote is in the statute and it's about the budget only, it sounds like the difference is that the voters have decided on a question. And we know what the decision was, and then it's a new offer and a new vote, whereas this is a different situation.
That is a fair way of framing it. Yes, the question has been answered, it's been answered no, and there's an automatic trigger for a revote to attempt to get the consent of the voters. And policy behind that particular provision in municipal elections is that a budget presumably must be passed and in time for a new fiscal year. So it's a very time sensitive vote that has to happen, and the automatic procedures make sure that it happens within a certain time frame.
All right, team. That was another productive and dense afternoon. Council Tucker, thank you so much for all the effort and time and education and insight you've provided us as always.
Thank you for having me.
We are going to call it for the day. We have to get up to the floor. and we will pick things back up.
Yeah, just to let everybody know that at 4 o'clock in the room, there will be something else.
Oh, yeah.
happening.
Thank you.
Yeah, no, there's another committee meeting in here at 4. So if you have personal, yes,
Yes.
if you have personal effects at your desk, please put them in a tiny spot. Because other people are going to come in here for a joint meeting of some sort at 4 p.m.
It means